This is a case involving a petition to confirm a non-agreed CSRP order. The CSRP took place on February 10th, 2025, and at the time the petition was filed, it was the state's understanding that the only matter in dispute involved the geographic restriction. The CSRP order had Ms. Moore as primary, with the right to designate the child's primary residence in Bell and contiguous counties. We were here for a docket on February 20th, 2025, and it appears that there may now be a disagreement by both Ms. Moore and Mr. Avert on perhaps all the other issues. Mr. Avert did sign the CSRP order. Ms. Moore did not. You appointed Ms. Lambert as attorney at Litem at the February 20th, 2025 setting. She has indicated she needs a continuance to complete her investigation. We do not oppose her request, but we know that we need to get at least a temporary order due to the time-sensitive nature of this case. Thank you.
All right, Ms. Lambert.
Thank you, Your Honor. I agree with the state that my understanding when I first received notice of my appointment on February 20th was that this was a non-agreed CSRP that was signed by the father, giving the implication that he was agreement with all of the terms. And I assumed at that time it was a mother who did not agree. And I do understand that originally, I think the one contested issue was just the geographic restriction. The father made first contact with me on February 26th. We scheduled our interview for March 4th last week, during which time I spoke to him, and he was then requesting to be made primary conservator of the child.
We're not going there, Ms. Lambert. We're not going there.
Okay.
That wasn't part of this. That wasn't part of the non-agreed to child support review order. Yeah, I do not see any counter pleadings on file. I do not see service on mom. I don't see anything like that. That's not before the court this time. So go ahead. I'm sorry.
It's okay. No, perfectly understood. And so in regard to when I spoke with the mother, which was just yesterday, and that was because we scheduled her for Monday. There was a work conflict with her new job. And so yesterday was the quickest we could get in. So I've only talked to both parties briefly once. And so she is in agreement with the geographic restriction. And so the other issue was possession and access. I believe in the CSRP, there was a standard possession order. She presented some concerns to me that seemed to show perhaps a lack of an established relationship that would warrant a standard possession order, being that the child is not one yet. And so, Your Honor, if the court so sees fit, then I would ask for additional time to be able to make an appropriate recommendation regarding possession and access. If the court wants to do temporary orders today, then I would ask that they be joint managing conservators. Mom is primary, dad to pay support, and setting up some type of modified visitation schedule, starting with full day visits on the 1st, 3rd, and 5th. Weekends of the month, building up to a standard possession order. I think you may hear testimony from the parties if we go forward today regarding the geographic restriction, with the father obviously seeking it, the mother asking if the court not granted it. She's already turned down one career opportunity that would have.
Ms. Lambert, you went silent.
I apologize, my notebook hit my computer. So I think you'll hear testimony from the mother today that she would ask that the court not enter the geographic restriction, as she has recently already declined one job opportunity that was advancement in her career, better pay, better hours, based on the pending geographic restriction that's currently before the court. I think the current order would have dad paying less than $200 a month. And so that fairly small amount of child support does not overcompensate for the job opportunity she has had to decline, what she would continue to have to do if the geographic restriction is confirmed by the court today.
Tell you what, let's get some testimony on that geo restriction thing. I'm probably looking at doing at least a temporary order today to give everybody the opportunity to do what they think they need to do in this matter. But again, I want to get some background on that, and I want to get some background on I got the child in this matter is what, 1 year old, less than 1 year old?
Less than 1 year.
Okay, so obviously standard doesn't start technically until the child's over the age of 3. So I need to get some testimony to what kind of relationship the father's had with the child up until this point. And let's see what kind of visitation he had prior to this date. I hate when those things, when all of a sudden we get to court, everybody wants to go backwards. So we'll see what that is also. So at this time, let me get some testimony from the parties. Let's see what they've been doing. Let's see what the mother is alleging, and let's find out what she actually does for a living, and And obviously, dad doesn't, well, if child support is below $200 a month, that sounds like it's a minimum wage circumstance or several other children involved. So I want to find out some data on that also. So at this time, let's see what we got at this, what the snapshot in time shows today. And yeah, obviously, to keep this thing going, I do need to come either make it a final order today, make a ruling and just move on, or go ahead and make a temporary order and come back with the other items being taken into consideration at that point. So at this time, I'll go ahead and let you finish that. Anything else in your opening statement, Ms. Lambert?
No, Your Honor.
All right, then, Mr. Avert, Ms. Moore, raise your right hands, please. You both solemnly swear or affirm your testimony going to give here today is the truth, the whole truth, and nothing but the truth so help you.
Yes.
Yes.
All right, thank you both very much. I'm going to go ahead and let the state call his witnesses, or they Litem. I'll let the state decide, but this is their case. So they get to make that decision who gets to go first. So at this time, Ms. Hopins, who do you wish to proceed at this time with the questioning of the witnesses, or you want to turn that over to Ms. Lambert for right now?
If it's okay, I'd like to begin with Ms. Moore.
All right, thank you very much. Ms. Moore, state your full name for the record, ma'am.
Kimberly Rayanne Moore.
All right, thank you very much. You may proceed.
Thank you, Ms. Moore. Please state the name and date of birth of your child.
Anthony Avert Jr., May 13th, 2024.
Thank you. And who is the child's father?
Anthony Avert.
Do you recall the CSRP you attended on February 10th, 2025?
Yes.
Is it true that you did not sign the order that was issued after that meeting?
Yes.
Yeah, I'm going to go through each part of the CSRP order and give you a chance to explain any disagreement. First,
Okay.
the order stated that Mr. Avert was the biological father of your child. Do you have any reason to disagree with that part of the order?
No, he is.
Secondly, the order had you and Mr. Avert as joint managing conservators of your child, and that you were designated as the conservator with the exclusive right to maintain the child's primary residence in Bell County or any contiguous county. Do you have any reason to disagree with these parts of the order?
Yes.
Okay, which part do you disagree with?
So I didn't agree with that, is what I'm saying. The geographical part. Yeah.
Okay, and can you please explain for the court why you disagree with that portion of the order?
Yes, because so right now I am a licensed unarmed security guard. I was working previously with Allied Universal. I was with them from 2021 up until just recently. I just started a new job that was better because I had to pass up the job in question that, you know, Ms. Lambert did bring up. I had to pass up and step out of security for the time being. So with security, what happened was I got offered a position, an opportunity to get my level 4 security license along with my private investigator license attached to that. With that, in that, I was going to get my level 3 armed security license as well, which opens up numerous doors for advancement and career opportunities. Once I got that, I would have been able to transfer accounts from a level 2 being paid $23 an hour to Texarkana, Texas, which was supposed to take effect in March this month. And due to all of this happening and the pending geographical, restriction, I had to decline that job offer that I had there with those opportunities.
All right, ma'am. How much? Wait, what was going to be the pay at that at Texarkana, ma'am? You didn't say that yet.
Oh, it was going to be $27 an hour.
So we're just talking $4 an hour more.
Yes, sir. However, due to all of this, I had to take a pay cut from $23 an hour to $17.50. So now I'm getting paid $17.50 due to all of this going on. So
okay.
that opportunity.
No, ma'am. You go. Okay. Ms. Hopins, you need yeah, ma'am, you're going way past the original question. We don't do narratives. We don't tell the whole story. The state's allowed to ask questions and get to the story. But again, since you're, I'll let the state ask the next question. And obviously, I think the state needs to ask something about why, how you came to about having to take a pay cut from a job that you had here originally, and now you had to take a pay cut because of not taking a promotion or something along those lines. But I'll let the state get into that. Thank you.
Thank you, Your Honor. Ms. Moore, did you want to explain the circumstance that led to the pay cut?
Yes, so there was a client requested cut that would happen. 40 officers were sent back to the branch, and I was upon that cut. So at that cut, it was supposed to be a transition from Taylor, Texas to Texarkana, Texas, to avoid a lack of employment.
Okay.
All right. So aside from the geographic restriction part, did you have any other disagreement with being a joint managing conservator with Mr. Avert?
As far as visitation goes?
Oh,
No,
that's the
no.
next thing.
Then no.
Okay. And then next, you and Mr. Avert were ordered to follow a standard possession and access schedule attached to the CSRP order. Did you have any reason to disagree with that part of the order?
Yes.
Okay, and please explain.
Just because he has not gotten AJ and spent time with him enough for him to know for certain that that is his father. That does a little bit concern me. It's only been a couple of hours here and there.
Well, kind of on that note, so has he been visiting with your child?
I don't even remember the last time that he saw him. I'm gonna be honest with you.
Okay, do you know approximately how many times he's seen your child?
Maybe like 10. Maybe.
And were these supervised or unsupervised visits?
Unsupervised.
And how long was the child gone?
5 to 10 hours max.
Were there any overnight visits?
There were a few in the beginning when AJ was newborn.
Okay, and then next I was going to ask about, Your Honor, about the support obligations in the order.
Go right ahead.
All right, Ms. Moore, Mr. Avert was ordered to pay you $193 a month in current child support beginning March 1st, 2025. Did you have any reason to disagree with that part of the order?
No.
Okay, and the next he was ordered to pay you $57 a month in cash medical support beginning March 1st, 2025. Did you have any reason to disagree with that part of the order?
No.
And are you providing health, let me start over. Are you providing private health insurance to your child through your employer or another source?
No.
And are you currently providing private dental insurance to your child through your employer or another source?
No.
Next, the order found that the retroactive or back child support owed to you by Mr. Avert between June 1st, 2024 through February 10th, 2025 was $1,624 as of February 10th, 2025, with a repayment assessed of $59 a month, with the first payment being due March 1st, 2025. Did you have any reason to disagree with that part of the order?
No.
And then lastly, the order granted no retroactive or back medical support or dental support. Did you have any reason to disagree with that portion of the order?
No.
Your Honor, I don't have any further questions. I pass the witness. Thank you.
All right, ma'am. Who's your current employer right now? Who do you work for at this time?
Movate.
I'm sorry, who?
Movate. Movate.
And what do you do for them?
I work for AT&T Business Solutions.
Okay. And what is your job title?
A service and sales agent.
Okay, thank you. All right, Ms. Lambert, you're a witness.
Thank you, Your Honor. Ms. Moore, you stated that you can't remember the last time that Mr. Avert saw Anthony Jr., is that correct?
That's correct.
Do you recall the last time he asked to see him?
No, I'm usually the one that initiates the visit.
Can you remember the approximate month, the last time that you initiated any communication with Mr. Avert about seeing Anthony Jr.
December, I think.
of 2024?
Yes.
And does Mr. Avert have a means to reach you, whether by phone, email, social media?
Yes.
And which of those methods do the two of you communicate?
On the app.
Are you referring to app close?
Yes.
Okay. And is that primarily how the two of you communicate regarding Anthony Jr.?
Right now, yes.
Okay. And prior to app close, how did the two of you communicate?
Per text message, over the phone, and then at one point, Snapchat.
Okay. Regarding visitation, you stated that he had a 5 to 10 hour visits, and then in the very beginning, Anthony Jr. was spending the night. Can you remember approximately how many times Anthony Jr. spent the night with his father?
I think it was like he was watching him overnight when I first went back to work. And I want to say it was like every night, like for 5 days in a row for like 2 weeks. So about 10 of them.
And is there any reason why you don't think overnight visits would be appropriate now, seeing that Anthony Jr. has already spent overnight time with his dad?
Yes.
And what would that reason be?
Because AJ, he is teething right now, and he's running consistent fevers. Anthony said that he couldn't handle him as a newborn, so it concerns me that he will be able to adequately take care of a teething, grumpy baby.
Okay. Do you have any concerns about Mr. Avert's behavior that would in any way place Anthony Jr. in harm's way?
No.
Okay. And do you know whether Mr. Avert is currently employed?
He's not.
Okay. Do you know whether he has any other sources of income?
Yes.
What other sources of income does he have?
I know for certain he gets paid from OnlyFans. That is for certain. And I suspect he is getting paid from Facebook as well. Also, in the past, he did tell me that he was his mother's caretaker, and that he gets paid as that role, but he gives her back the money.
Do you believe that it would be in Anthony Jr.'s best interest for Mr. Avert to start off with a modified possession schedule that began with perhaps full day visits leading into overnights and then into a standard possession order?
Yes.
Would you believe that, or would you agree that if the court orders full day visits, that something along the lines of every first, third, and fifth Saturday from 10 a.m. to 6 p.m. would be appropriate for the day visits?
Yes.
And that Mr. Avert perhaps could do 3 to 4 of those before he got to overnight visits?
Yes.
And then those overnight visits perhaps could be 6 p.m. on Friday to 6 p.m. on Saturday, and that Mr. Avert would complete approximately 6 of those if the court so orders before he moves into standard possession?
Yes.
Okay. No further questions for this witness at this time, Your Honor.
All right, thank you very much. Anything on redirect, Ms. Hopins?
No, Your Honor.
All right, ma'am, we'll be back in just a moment. I'm gonna let the state call your next witness. Thank you.
Thank you, Your Honor. I'll call Mr. Avert. All right. Mr. Avert, please state your name for the record.
Anthony Shaheem Lasun Kenyel Avert.
Thank you. And is it true that you're the father of Anthony Avert Jr.?
Correct.
Okay. Are you currently working, sir?
No, ma'am.
Okay. And do you have any sources of income outside of, you say you're not working, but do you have any other sources of income?
Unemployment.
Okay. And how much is that?
It's only 244 every week. So it's like like 640 once you total it, but it's only 244 for each of the weeks. Or is it 222? Something like that.
Okay. And when did you last work?
Last work day, August 6th. No, my last work date was May, because it was after AJ. Yeah, so it was May 25th of 2024.
Okay. And where did you work at that time?
Baylor Scott and White.
And do you believe you're capable of earning at least minimum wage when you are working?
Oh, yes, I am.
Okay. Aside from Anthony Jr., do you have any other children for whom you have a support obligation?
Yes, I do. Yeah.
Okay. How many?
One.
Okay. And do you recall the CSRP you attended on February 10th, 2025?
Yes, ma'am.
Okay. And like with Ms. Moore, I'm going to go through parts of that order to see which pieces you may or may not have a disagreement with.
Mhm.
First, the order stated that you were the biological father of Ms. Moore's child. Do you have any reason to disagree with that?
Nah, I did a DNA test, so no.
Okay. Secondly, the order had you and Ms. Moore as joint managing conservators of your child, and she was designated as the conservator with the exclusive right to maintain the child's primary residence in Bell County or any contiguous county. Did you have any reason to disagree with those parts of the order?
Is that the geographical restriction?
Correct, yeah.
Yeah, I'm the one that I didn't. Well, her maintaining and staying in with Bell County. Well, yeah, I'm the one that wanted that.
Okay, so Bell County or any contiguous county to Bell County?
Yes, correct.
Okay, okay. And then aside from that, did you have any did you have any issues with being joint managing conservator with Ms. Moore?
Did I have issues with it? I wanted primary conservatorship, but yeah. So that's how we ended up here. But that's the question is, do I have a problem with it? Yes.
Okay. All right. Next, you and Ms. Moore were ordered to follow a standard possession and access schedule attached to the order. Did you have any reason to disagree with that part of the order?
Isn't that's the regular three weekends out of the month or every other weekend or something like that?
Right. It lays out a schedule.
Yeah. That was
Right.
standard order. Okay. Yes. I was in agreement with that. Yes.
Okay. And the next, you were ordered to pay $193 per month in current child support beginning March 1st, 2025. Did you have any reason to disagree with that part of the order?
I was in agreement with that. Yeah.
And then you were also ordered to pay $57 a month in cash medical support beginning March 1st, 2025. Did you have any reason to disagree with that part of the order?
That part, no.
Okay, so you didn't disagree with that part.
No, I have a question, but I'll just hold off and ask it.
Okay.
I think it's probably coming up next.
Okay. Do you have access to private health insurance for your child at a reasonable cost?
I did, but no, not right now. No, right now, no.
Okay. And then do you have access to private dental insurance for your child at a reasonable cost?
Currently, no, ma'am.
Okay. So next, the order found that the retroactive or back child support that you owed to Ms. Moore between June 1st, 2024 through February 10th, 2025 was $1,624 as of February 10th, 2025, with a repayment of $59 per month, which was ordered to begin March 1st, 2025. Did you have any reason to disagree with that part of the order?
Yeah, I 100% disagree with that
Okay, and why is that?
because I've been providing everything for him. I've provided everything for him since I've been there, since he's been born. And then in regards to the back, the back pay, I guess the back pay Medicaid is also going to be included on there. He was held under my insurance all the way until August 4th.
Well, this has to do with the back child support. It doesn't include medical support or dental support.
Okay, just wanted to make sure that. All right, well, yeah, that's fine. I
Okay, so
don't agree to it though. No,
you don't agree? Okay.
no, ma'am.
And it's just because you say that you have been providing
I've been there since he's born.
payment?
I've been there, yeah. I've been providing payment, been there since he's born, buying everything for him, anything he needs, give it to him.
Have you provided? Oh, go ahead.
Go ahead. You getting ready to ask the question I was getting ready to ask. Here we go.
Go ahead, I'm listening to you.
Okay. Did you provide direct financial support to Ms. Moore since the child has been born?
Did I give her any money? No, I did not give her any direct money, but the child has not been in her possession for 6 months since after he was born.
Okay. What do you mean by that?
He has been living with the babysitter.
So if you haven't given like direct financial, like money payment in the form of money, how have you provided financial support to the child?
Anything that he is need, the babysitter can't depend on her to get it, so she contacts me and she'll call me and say he needs clothes. I go and I take him clothes. He needs this, I go and I take him that. You know, if he needs clothes, he needs formula, I provide it. That I would pick him up, he would be in my possession, I would watch him, but as we see, I haven't got to the point. I don't know when I will be able to offer in my evidence from so once we get there, then we can go all the way into the meat and bones of everything that's been going on.
Okay, and that may be pertaining, Your Honor, to the conservatorship, possession and access issue, Your Honor. Okay, and lastly, the order stated that there was no retroactive or back medical support or back dental support that was granted. Did you have any reason to disagree with that portion of the order?
You said there was none? That was
Correct.
basically the question that I just asked previously about me carrying a health insurance form, right?
No, this is a little different. This has to do with like the back, the back medical support and dental support. I don't. Was there any evidence of that at the CSRP?
Oh, that when I asked them about when I asked her about that, she said it was being like back, like that was going to be included as if like with the back pay of like I have to still pay that back because they're charging that, including it into the back pay. So that's why I said I held he was on my health insurance all the way until August. So that's where the mix up is right there. That's why I asked that question.
Okay, and how much were you paying to provide health insurance to your child?
It was through my employer and it went up to like $30.
Is it $30 per month?
$30 out of my paycheck each month.
Okay. So that was from May to August? Okay. Of 2024?
Correct.
And then relevant to the court costs issue, do you have any prior military or first responder experience?
I was in the Army in 2013.
Okay. All right. Thank you for your service. And on the CSRP order, is it true that you signed that order?
This is the very first one. Yes. Yeah. I signed it. If it shows that I signed it, then yeah. I signed it.
And did you read the order before you signed it?
Yes. This was because initially, if you're talking about the order that was sent where I put in the geographic restriction, then yes.
Okay.
It was a bunch of orders going back and forth that day. So the last order that was discussed was the geographic restriction, and then we ended up coming to here because she didn't agree with it.
Okay. And did you understand the order before you signed it?
For the most part, yes.
Okay. What was it that you didn't understand?
Well, I asked the question on it. Like I understood it. The standard visitation, and then I'm responsible for paying child support of $193, that amount.
And then my last question has to do with the visitation. Approximately how many times have you seen Anthony Jr.?
At least what? I try to go and see him, so at least 20, 30 times.
And for how many of those visits were overnight?
Overnight, are we including the first 2 months that I had him of his life?
I mean, just overall.
If we're including that, then that's 60. And I'm pretty sure overnight we got to a point, so I'll say like 65. At least, oh no, at least, no, yeah, 65, because I haven't had him overnight. We got to that, yeah, 65.
So 65.
65 or 65?
65. My apologies. 65.
So you've had, just so I understand, so you've had the child overnight approximately 65 times?
I had him pretty much every day when he was first born.
Okay.
While she was still working.
And when was the last time you saw Anthony Jr.?
Let me see. When did I? Just in, when did I pick him up? End of March, beginning of February.
So is it end of January, beginning of February? Just so I understand.
I said
March.
oh yeah, beginning of end, like towards like the beginning of March, like the end of February.
End of, okay, I apologize. Okay,
Yeah.
Your Honor, I have no further questions.
Okay, you lost me on that one. The end of March, beginning of February. That doesn't work out that way.
I know. I'm thinking about it. Give me.
Did you say beginning of March, end of February of this year?
That's what I'm trying to say. Like the beginning of when did I send?
Today's the 13th day of March, sir. So we're technically in the first half of March right now.
Yes. Okay. The exact
Man,
date.
stop that.
I just had him because
Stop
I just had him because I took him to a baby shower with me. So I'm trying to I literally just had him. I had him on a Saturday. I don't remember. It's in my I had to look and see exactly. But
And sir, how many times over the last 2 months are you saying that you've had the child with you in one manner, way, shape, or another?
that I've had him in the last 2 months.
60 days. Yeah.
Since the
we had the order. I'm sorry.
The order was placed on the 10th. So I didn't have him after that order situation. So it had to have been before that, if I'm correct.
Okay. All right. Good enough. All right. Your witness then, Ms. Lambert.
Thank you, Your Honor. I just want to clarify. So, Mr. Avert, this order was February 10th, was the date that the order was obtained. Is that correct?
Yes, that's what I remember. Correct.
Okay. So then how is it possible you have the child? You just said you haven't had the child since the order. So how is it possible that you had the child at the end of February, early March?
Second, December, January. So it had to have been, God, chill out.
Mr. Avert, isn't it true you told me that you haven't seen the child in at least 2 months?
Yes.
Okay.
Yes. That's why my dates are definitely off here because I'm looking at my notes. So it had to have been in January.
Okay.
It had to have been January when I seen him.
Thank you. And so you mentioned previously in your testimony, when you were speaking as to how often you see him, you said, you know, I tried to go see him. Where is it that you go to see him?
Babysitter.
And you're saying the last time you did that was in January of this year?
Yes.
You mentioned previously that you had the child for the first 2 months. Were you and Miss Moore living together?
No, ma'am. She would, oh, go ahead.
And so what was the arrangement in which AJ was with you for those first 2 months?
I was keeping him overnight.
And why was that?
She had to go to work.
Okay. So was she picking him up each day?
Yes, every morning.
So you would keep him overnight while she was working nights?
Correct.
And why did that stop after the first 2 months?
So it was getting, so like when he was first born, he would scream and scream and scream all the time, which, yeah, that was cool. You know, it was like, it was rough. Note, this is my first child. So,
okay, sir, stop. Listen to the question, answer the question. The question
Why?
Why did it stop? Why did that change? Yes, sir.
She says that she feel like she was going to get him another babysitter.
And is that after you communicated to her that you felt overwhelmed?
That I said it gets rough, correct.
Okay. You mentioned that you have a second child, is that correct?
Correct.
And when was that child born?
9/23/24.
And does that child live with you?
No,
Do you pay child support for that child?
no,
Has there ever been an establishment of parentage, your name on the birth certificate, and acknowledgement of paternity or DNA testing?
I'm on the birth certificate.
Okay. And where does that child live?
San Antonio.
And so Bexar County doesn't touch Bell or any of the other counties, is that right?
No,
Okay. And do you have any plans of ever living in the same county with that child?
no.
Regarding your income, you stated that you're currently just receiving unemployment.
Correct.
What was the nature of your separation from your last employer?
Just basically they said they laid me off.
And what was your job title at that time?
Pharmacy technician too.
And are you still seeking work in that field?
Correct.
Have you had a job interview or a job offer recently?
Yes, I was supposed to start training today, the 13th, but I had to turn it down because I had court.
You heard the mother's testimony that she believes that you receive income from social media sites, including an OnlyFans and perhaps Facebook. Do you have any response to that?
I do not.
Do you have an OnlyFans account
Correct.
and you don't generate income from that account?
No,
You've not received a 1099 for that account?
no,
And the same question for any other social media? Any 1099 for any income received for the last year?
no, ma'am.
Okay, and I don't think I have any further questions for Mr. Avert at this time.
All right, the mother seems to be biting at the bit. I'll let you let Ms. Hopins go back and recall her for a moment and then let you recross on that one, and then we'll come back to Dad. All right, sir. Who was the job with that you allegedly had to start today, sir?
What did you say, ma'am? I mean, sir?
You said you had a job that was supposed to start today, but you turned it down, correct?
Yes.
Who was it with?
It was a work from home pharmacy tech. Hold on. Because I've been applying. I've been getting interviews, but I can tell you exactly which one. Didn't expect that question here. My apologies. My jobs. Skip for now. It was a work from home C4 technical services. It was a remote job.
And what was it gonna? What were the hours and what was the pay?
The hour was Monday through Friday, and the pay was $24.
40 hours a week.
Correct.
All right, you couldn't. Okay, I'm not gonna go there.
It was the train. It was the training.
Any other
So,
job offer? Have you had any other job offers this year, sir?
no, sir.
All right. And what kind of, do you have any special licenses or degrees or anything as far as your profession is concerned, sir?
Yeah, I'm nationally certified as a pharmacy technician. So any 50 states, I can be a pharmacy tech in.
All right. And you said Scott and White laid you off?
Yes.
Which Baylor Scott and White were you working for?
The CDM in Temple.
Okay. All right. Thank you very much. I'm going to be back in just a moment, sir. Thank you. Ms. Hopins?
All right, Your Honor, I'll recall Ms. Moore.
Okay,
Ms.
thank you.
Moore, were you able to hear Mr. Avert's testimony?
Yes.
Okay, did you have something to add?
Yeah. So I'm not sure what he means by for the first 2 months of his life. I didn't even go back to work till I was 5 weeks postpartum. That's the first month of his life. And then he was only watching him overnight, so he didn't have him for the first 2 months of his life. He had him for a few hours overnight while I went to work. And then also, he does not live with the babysitter. It's the same thing. I don't expect Mr. Avert to understand that sometimes you have to work overtime. I don't expect him to understand that you have obligations that you have to do, you have to take care of when it comes to children. AJ is not my only child. I have 3 that I do it all by myself for. So yes, it is true. The babysitter would have them 6 to 7 days a week. However, I picked them up in the morning. On occasion, she would say, hey, you worked 7 days this week. Go ahead, I'll keep them since you're going to bring them back tonight, or I'm going to pick them up tonight, and they would stay for the entire day. That is correct. However, he did not live with the babysitter, and that bamboozled me. I was just shocked that he would make an accusation like that.
Okay, I didn't hear him say live, ma'am. I heard him say he goes over the visit, but I didn't hear anything about living, so.
I did
No,
say
he
that.
said that AJ lives with the
Oh,
babysitter.
AJ lives, okay, all right. And who's been paying the babysitter all the, for these, for those times that the babysitter has your children, ma'am?
I have been paying the babysitter since we started, with the exception of 1 week. Mr. Avert paid 1 week, and I believe it was back in July.
Okay. All right, and do you know anything about him going over to visit the child at the babysitter's?
So I did okay it. However, the babysitter advised me that she did stop that due to him coming very, very late at night. So as far as him coming, I believe it was in December when she stopped that. So yeah, other than that, nothing
Okay,
more.
thank you. All right, next question, Ms. Hopins.
Your Honor, I have no further questions. Thank you.
All right, Ms. Lambert.
I have no further questions for Ms. Mariano.
All right, folks, lawyers. Sounds like a temporary order to me. What are y'all asking for? And I'll start with that Litem and then go to the state. Thank you.
Thank you, Your Honor. In a temporary order, I would ask that the court would appoint the parties joint managing conservators, making Ms. Moore primary. I would ask that the court would perhaps hold the geographic restriction, at least in abeyance, until a final order or additional testimony or evidence is given, if it will have any effect on the mother's career. Asking that visitation be set up for Mr. Avert, but asking that the court would start with a full day visit. Is not even one yet. Mr. Avert has already testified to feeling overwhelmed by the child when he did have him overnight, asking if the court would start those visits from 10 a.m. to 6 p.m. on the first, third, and fifth Saturdays, doing at least 3 of those visits leading into overnights, 6 p.m. on Friday to 6 p.m. on Saturday, doing 6 of those. If we're not back before then leading, Your Honor, into weekends, and then ultimately a standard possession order. With no evidence that Mr. Avert has additional income, just asking the court confirm the previous findings regarding child support, medical support, dental, and retroactive support as well.
All right, thank you. Ms. Hopins?
Thank you, Your Honor. The state is not opposed to confirming the child support review order as it is laid out, and I have no disagreement with Ms. Lambert's proposal in relation to possession and access and conservatorship.
Thank you. All right, I'm going to start with you, sir. Anything else? You heard what the lawyers are asking me to do here today. What are you asking me to do here today?
They're asking. Could you repeat it for me?
No, you heard what the attorneys are asking me to do here today as far as your temporary order is concerned. What are you asking for, sir?
The one overnight visit, like, so basically what you're saying is I'll just be able to see him for 8 hours when I've gotten him overnight multiple times. So that's why I'm really
confused. Sir, don't try to phrase it around us. We're all lawyers, okay?
I'm not at all.
The question is, the ad litem is requesting that you get full day visits the first, third, and fifth Saturdays of the month, okay? That's what she's requesting.
Okay.
What are you requesting?
First, third, fifth Saturday. And you're saying that's from what time? 10 a.m. to
5 or 6, whatever I decide, sir. Yeah.
10 a.m. to 5 or 6. Okay, it's fine.
Okay. All right, anything else, sir, you're requesting at this time?
So is this going to be continued on into like a later date? Is there a chance that we'll be able to go over the evidence that I offered to the court?
All right, here's the deal, sir. Okay, yeah, we're gonna have another hearing.
Okay.
Here's the deal. You know, yeah. okay, I'm gonna put this delicately, you're not a lawyer, but I gotta hold you to the same standard of trying to present evidence as if you went to the University of Texas Law School, graduated, passed the state bar of Texas, and know exactly what you're doing, okay? Because I don't have, this is, as a court of law, well, I'm not gonna say I don't have time, but yeah, technically, I don't have time to teach pro se litigants how to practice law. When you come in and you're gonna do it yourself, be ready to rock and roll and do it properly. Otherwise, it's not gonna get done, sir. I do this way too often, and I get pro se litigants who get stuff on the internet, and it's not correct. So, but
Yes,
this time, and sir, yeah. No, okay, I won't make a comment at this point. Anyway, we're probably going to be back in the next 60 days, and we're going to wrap this up one way or the other. And is there anything else at this point, sir, you're requesting that we do in the temporary order? That's what I'm asking at this point, sir. Thank you.
the temporary order, can you explain to me, so with this going on, am I going to be putting back, because right now that's going to put me at like what? Because it was supposed to start in March. That's going to put me like 2 months behind. Am I still responsible for this child support order, or we're still waiting until we get all the way to the
You're
end?
still responsible for the child support order, sir.
Okay.
Yep.
Okay. So do we have time for me to offer the evidence in my exhibits 1 through 9?
No, sir, we've already that you should have done that when you were earlier, sir. Right now, we're in closing statements. The lawyers have already closed. We are now making their closing statements. They've made their closing statements. Evidence has been closed, sir. And what evidence do you have, sir?
So I have evidence, pretty much just so evidence 1 through 9 is just shows that like it shows everything that has transpired.
What kind of evidence are you talking? What kind of evidence it is, sir? Is it photographs? Is it documentation?
It's images. It's images.
Okay, here's the deal, sir. Here's the deal. You got to learn how to put that into evidence, sir. You just can't show a picture and have it placed in evidence. You're going to have to learn how to place a photograph in evidence and it be accepted as evidence, sir. And again, it's not easy, but anyway. Okay, but right now, sir, evidence is closed. We're in closing statements, closing arguments for the temporary order, and that's why I was asking, is there anything else you're asking for in your temporary order, sir, as a closing statement? No, sir, you cannot present your evidence at this time.
Yes, sir. Okay, so what I would like to add is that with me getting him, I don't feel safe picking him up from her. I would like to meet at the local police station that we have here.
And sir, I heard there was nothing testified to earlier about any type of family violence or any type of threats or anything along those lines. The standard order says pick up and drop off is your responsibility. At her residence is the norm. Why? I didn't hear any testimony why that should not be it going forward. Why should that be the case going forward, sir?
Why? Because she is verbally abusive, 100%. It was in the evidence that I messed up and didn't say at the beginning of offering. I should have said at the beginning. I have it on here in my notes. I didn't, but it's in my evidence that shows the way that she speaks to me. Never rude, disrespectful, and just don't care. So I'm like, and just recently I didn't add it into there, but she told me that I better get a lawyer because, threatening me again. So I don't want to have to deal with her in like a
Okay, here's the deal, sir. Threatening you to make you get a lawyer is really technically not a threat, okay?
Yeah. Yes, sir. I understand.
All right.
But that's
thank you, sir.
What I'm requesting.
All right. Anything else, sir? You're asking for in the temporary order. That's what's before the court in the closing statement. Anything else, sir?
No, sir.
All right. Ms. Moore, anything else you're asking for other than what the lawyers are asking for, ma'am?
No, sir.
All right, ma'am. Here's the deal. The father's requesting. What city you live in right now? Just your city.
Pauline.
Okay. All right, sir. And if the court was to go ahead and grant the first, third, and fifth Saturdays of the month from 10 a.m. to 5 p.m. For the dad to have visitation until further order of the court, and that's what I'm probably looking at right now to make sure it takes place. I'm not going to do a graduated schedule until I see how everything else goes. The 10 a.m. On Saturdays, what location would the child normally be at based on your work schedule, ma'am?
Well, right now I'm in training, so I'm only working Monday through Friday. However, at the end of the month, I will be required to work a Saturday. So most likely at 10 a.m., depending on my schedule, he will be with my babysitter, Kat.
Okay. So here's the deal. So is there any problem with him picking up and dropping off so long as he knows the correct spot, either your place or the babysitter's?
No, no problem.
Okay. All right, that's what I'm going to do. All right, sir, I know that was no, I will find that out. We'll find that out at the final hearing. So, all right. So here's what I'm going to do, folks. I'm going to go ahead and make a temporary order. I'm naming you both temporary joint managed conservatives. I'm giving mom the right to decide domicile for the temporary order. I'm making that Bell and contiguous counties. I will look at a geo restriction or a geo lift based on the testimony at the final order. So, ma'am, here and sir, y'all need to get your ducks in a row. Why I should do it and why I shouldn't do it. And obviously, mom's got more than one child to deal with, and mom has a certain responsibility to take care of all those children and earn a living. And so I need to know what we're looking at and whether or not she plans on going back into the her old job and need to have the court lift the geo restriction. And I'll take that up at final. I'm gonna go ahead and order temporary child support based on the minimum wage presumption. But here's the deal, sir. When we come back, have a job. You're well too trained to be, I'm not sure why it's taking all this time for you to find a job, but you, with your background, you're not going to be making anywhere close to minimum wage under your profession, sir. And I will have the ad litem bring in evidence, and I'll let her know ahead of time to find out what somebody with your experience and background should be earning. And that's what I'll probably be ordering child support at, sir. I'm not going to be ordering a pharmacist tech to pay child support based on $7 and some change. It's just not going to happen. All right. So that's that. I'm going to go ahead and take up again all issues at final as far as this circumstance is concerned. Ad litem will complete her investigation and make recommendations at the end of the day. And we'll try to figure out what we're going to do is in your child's best interest and how the court's going to set that up one way or the other. So at this time, is there anything specifically and everything else in the child support review order will become part of the temporary order? Is there anything else I specifically need to rule on for you, Ms. Hopins?
Your Honor, costs, are those waived due to his prior military?
Well, you sound like you're
reserved?
going in the military 1 year, and that's not right. Sir, were you honorably discharged from the United States military?
I got a general discharge on the honorable conditions.
Okay, then I'll waive court costs.
And then if Ms. Lambert, the specific schedule that you recommended.
I believe the judge is just going to do first, third, and fifth day visits, 10 a.m. to 6 p.m. until we come back.
Is it 6 p.m. or 5 p.m?
I made it 5. I said 5.
Sorry.
I'll go ahead and make it 6. That way he's got 8 hours. Okay.
And is there a specific address? Obviously, we're not going to say.
They got to communicate with each other going forward by app close. And obviously, the first, third, and fifth Saturdays is easy enough to take care of. Remember, okay, because this is the third Saturday of the month coming up. This current Saturday. So here's the deal, ma'am. You, sir, going forward through app close, you let mom know by 6 p.m. on each Thursday night you're supposed to have the child, that you're going to pick the child up, and she will let you know at which address to pick a child up going forward, because this is the 1 month that there are 5 Saturdays in the month, the 1st, the 15th, and the 29th. And then, of course, the very next Saturday, the 5th of April, is again your visitation, sir. So again, on the Thursdays before 6 p.m., let mom know that you're going to exercise your visitation, and mom, you let him know what address he's to pick the child up at 10 a.m. and where to drop the child off at 6 p.m. Okay. All right. Next, Ms. Hopins.
The only other thing, so the geographic restriction is, so you're holding, I guess, in the temporary order that it's limited to Bell and contiguous counties.
Yeah, for the temporary order, but we'll look at the final hearing and whether or not I'll keep that, and based on the circumstances of the parties and the job opportunities, we'll take a look at it. Here's the deal, folks. I want to make sure parents have the right to see their child and and visit with the child. but I will always look at economic opportunities for the party. If there's a legitimate job with more pay, and ma'am, I'm probably looking at more than $4 an hour. You know, that's just not a lot. Okay, you know that's extra. With 4 kids, it probably is a lot, but you know, it's an extra $160 a week. So I know it's something, but it may not get you there where you need to go as far as me lifting the geo restriction. But I'll always look at those opportunities, and I'll look at the history of payments as far as the parties are concerned. I'm going to hold to the final hearing to retro, but sir, things you buy don't count. I look at cash money given to mom. Child support is for mom to spend the money where she wants, when she wants, and how she wants, with a custodial party. And for you to do it how you want, when you want, and where you want, doesn't count. All right, unless you're like the gentleman who was paying for mom's Mercedes-Benz payments at $860 a month. And if you're that guy, then yeah, I'll give you $860 worth of credit. Okay, so. But unless it's something major like that, I will give you, if you bought a bedroom set or something like that, get your receipts and I'll look at giving you credit for that. But we'll hold in advance the retroactive child support till the final hearing. All right. Anything else, Ms. Hopins?
No, Your Honor. Thank you. Did you want me to look for a date? For
I'm going to look at the date.
Oh, yeah.
I'm going to look at dates, and I'm going to run that by Ms. Lambert. Before I do, Ms. Lambert, anything else, ma'am?
No, Your Honor, thank you.
All right, I will start with you, Mr. Avert. Question, sir.
So you said we're waiting to decide, or I am responsible for the retro.
Oh, I'm going to make you responsible for retro, but I'm not going to do it to the final order, sir.
Okay.
And we'll do the math at that point. And like I say again, sir, I'm holding in advance the right to do it based on what you should have been earning or what you or minimum wage. Because again, you're not a minimum wage person, sir. When's the last time you earned minimum wage in a job?
It's been a while, but the market, I put in applications every day. The market is really rough right now. Everybody has their pharmacy techs.
All right, then. Well, we'll see. But again, I'll hold that, but I'm going to hold that in advance at the time, and we'll figure that one out. And right now, any other questions, sir?
Let me hold on. Okay. No. No, not nothing that can be. It'll have to be discussed at the I guess at the next hearing then.
All right, then. All right, Ms. Moore, questions, ma'am?
No, sir. Thank you.
All right, and y'all have been using app close. Everybody's set up on it and ready to go, correct, ma'am?
Yes. However, Mr. Avert doesn't have the phone call feature or the video chat feature enabled, so it's only text messages. So if he would like to video chat or something with the baby, I don't know if that's allowed, if it's not in the order, but that would need to be enabled in order to do that.
All right, sir, I want you to go ahead and enable that. And ma'am, well, again, I normally do video chats like that, but it's usually for people who live distances away because dad's gonna be able to see the child for his 8 hours on those Saturdays. And right now with your schedule, I will it makes it a little difficult for me to plan around because if the child's with the babysitter, then the video chat's probably not going to work. So I'm just going to go ahead and tell him to have that enabled by the final hearing where we can set something up going forward. And how long are you going to be on right now you're in the early stages of your job. You haven't been hired as a final permanent employee. Is that correct, ma'am?
No, I am hired. I'm just in the training portion, so they're teaching me the job right now.
All right. Is there a probationary time frame with that, ma'am, or is that
90 days?
Okay. And when's your 90 days up?
I got hired March 3rd.
All right. So 90 days out, we'll put you in June. Okay. So April, May, June. So I was looking in May to finish this up, but I want to finish it up after the 3rd of June. So that way we know the job is permanent and what you're going to be earning and what your circumstances are going to be. So let's see. All right, then. Well, Belinda's not here, so she can't tell me if I'm lying or not. But right now, Ms. Lambert, I've got nothing on my special setting dockets all day on Wednesday, June the 11th. What's your schedule look like on that date, ma'am?
That should be fine, Your Honor.
All right. So if ma'am, and sir, well, sir, you obviously you're not working right now. So ma'am, if I was to set this for a final hearing, based on your job schedule and your what you know about your job, would the morning or the afternoon on that Wednesday be a better time for you? In other words, you can go to work on in the morning and leave early, or you go in late. Which works better for you, ma'am?
Morning.
Okay. All right, folks. I'm going to move this Zoom code to 9:30 a.m. on the 11th. Yes, sir.
So let's say, because like I said, I'm not going to turn down no more. You know what I'm saying? Like I said, I had a job. So what does that put me at? Let's say if I get a job, but once again, and they say I can't miss no days of training, but I have to go to court. So do I still
let Miss Lambert know, and we'll change that around to base with your work schedule, sir. Okay.
That's fine.
But if you do get a new job, let Miss Lambert know and let her know the employer and get something verifiable in writing that you do have that new job, because we're probably going to do some new child support too. So yeah, all right. Okay. But for right now, sir, it's going to be June the 11th at 9:30 a.m. Same Zoom code.
And Your Honor, I apologize. I'm not seeing a June 11th docket, but
That's because I hadn't said anything yet.
makes sense.
Well, Wednesdays are special setting dates, and I've got nothing on that date so far. So yeah,
Okay.
that's why it's not popping up.
Thank
All
you,
right.
Your Honor.
Do
All
I
right.
just
Yes, sir.
pay this online?
Yes, sir. You can go to the Attorney General's website, and there's several different methods for you to do it. You can pay it online. You can pay it at by Western Union at any Walmart or any CVS pharmacy. It's called MoneyGram. You just use the paper. You just use the OAG number at the top of the pleadings you have in your possession, sir. That's the number that's right beneath your name.
Okay.
All right. But if you want to do it online, there you can do it online. All right. Anything else, folks? All right, then. I'll see everybody. Obviously, if there becomes an emergency circumstance, something happens that's totally unforeseen, then everybody's to let the ad litem know, because the ad litem knows how to get back before the court before the 11th if we have to come back in before that date. All right.
Okay.
All right. I'll see everybody on the 11th. And parting, sir, I see the gaming computer in the back. It better not have an NVIDIA 5090 in it. Otherwise, I'm going to raise your child support like crazy. If you can afford a $2,000 video card.
No, that's not what it got. I got an AMD 3.
What now?
AMD?
Okay, I know AMD. I got AMD too, but yeah.
I don't have it. No, not the. I know what you're talking. That's pretty expensive.
Yeah, they're 2,000 a pop these days. So yeah, I'm thinking about it, but no, we're not going there. All
Yes,
right.
sir.
All right, see everybody on that date. And again, if there comes an emergency circumstance, let them know, and we'll get back on a date before that time frame. And I'll see everybody then. Thank you both very much. And again, if the state needs to come back and clarify or needs something else clarified, just let me know. We're off the record.